We are here for a calendar call of cases to be tried tomorrow. Mr. Hollander, are you ready to address your matter?
Judge, my client's reading the plaintiff.
All right, very well. And, this is Mr. Basties, if I'm pronouncing that correctly?
Yes, Judge.
Hey, welcome, sir. Good morning.
Morning. Judge, we're going to enter a plea this morning.
All right.
We worked it out with the state. We will be asking the court for a 2-week surrender date. So
I'll wait till you're ready. I can recall it when you're ready. Mr. Verderamo has arrived. He has the second case. Mr. Verderamo, are ready to address the Onfroy matter? Onfroy?
Good morning, Your Honor. Derek Verderamo for the record. Mr. Oswald, I'm always coming in.
Very well. I don't see Mr. Zonas at this time.
He's a call.
All right.
Speaking at this point.
Very well. Do you need a few moments to speak with Mr. Onfroy?
Thank you about his wife. So I'll grab him.
All right. Are you ready to proceed now?
Yes, we're ready to go.
All right, let's begin with Mr. Onfroy then. Oh, state. Okay. All right. Very well. Mr. Hollander, do you need additional time?
No, we're ready.
Who is opposing counsel? Mr. Ashby? All right. Are we ready to address Mr. Basties?
All
right. Let's have Mr. Basties approach. This is a 20 CF 0172. Mr. Hollander for the defense. Mr. Ashby for the state. Welcome back, Mr. Basties. Please be seated. Thank you. Mr. Hollander, this matter was set for jury trial commencing tomorrow.
Yes, sir.
What is the status?
This time, Judge, we are going to withdraw our previous plea of not guilty, enter a plea to the charge. The agreed upon disposition is an adjudication of guilt, 24 months Department of Correction with credit for time served.
Has that been
That
reduced
has not been calculated. I'm sorry. We could work this out like Friday afternoon.
I understand. We do need a number for the department.
We can't let the jail records.
No, I think we do for Department of Corrections. We do need to list the number of days. Mr. Ashby, do you have access to that at this time?
I can see if I do.
Now, I believe you mentioned earlier, Mr. Hollander, this is going to be a deferred imposition of sentence.
We're going to request it, Judge, by 2 weeks.
Will the state be opposing that?
No, Your Honor.
So we could perhaps at that time have the information, if you can get that from the jail then by that time, Mr. Hollander?
Yes.
But for today's purpose, it would be credit all times.
Correct.
All right. Additional?
The 24 months will be followed by 3 years probation, a $500 fine, 12 months driver's license revocation, 50 hours of community service, DUI school appropriate phase, 10-day vehicle impound, victim impact panel, no possession or consumption of alcohol, substance abuse evaluation, follow recommendations, random testing, 6-month ignition interlock, restitution will be ordered and reserved to Connie Jean Yates, previously known as Connie Jean Stuker, S-T-U-K-E-R. Give me 1 second, Judge. Actually, I think the other way around. She's now Connie Stuker Yates. Oh, court costs and costs of prosecution. And there was one, um,
Madam Clerk, what are the court costs?
Judge, the court cost is $583, but if I do all this today, it's gonna be off bond.
Right, this will all be deferred.
So we're just gonna plead the no contest when it comes back.
Right.
with the defense.
Just
Okay.
announcing all the terms and doing the colloquy, but the court will grant the request.
and there's one more condition,
Yes,
that he can apply for early term, petition for early termination after the halfway mark of probation, assuming no violation.
any investigative costs, Mr. Ashby?
No, Your Honor. And Your Honor, you'd also be requesting a date on 9 days out for the restitution hearing. The victim is currently collecting documentations. You may not need a hearing date. Once I present have those documents, they will present the defense. However, they would like to have that date set now, that way we have it. And if you don't need it, you want to get it out, send it order to Your Honor.
Would that involve Mr. Bassey's returning to court for that, Mr. Hollander?
If we're going to contest it, I don't know, I mean, if she's got all the bills lined up and there's nothing to contest, there's no reason. I mean, I'll be in touch with them.
Any other clarifications from the state?
Nothing to say.
Mr. Ashby, is there any victim opposition or law enforcement opposition to the plea agreement?
No, Your Honor.
Was there any victim impact testimony to be presented?
No, Your Honor.
So the victim has been informed, has declined.
Yes, Your Honor.
Mr. Bastes, after speaking with your counsel, do you believe this plea agreement is in your best interest?
Yes, Your Honor.
Do you prefer this instead of having a trial tomorrow on this case?
Yes, Your Honor.
Mr. Hollander, he is requesting a deferred imposition of sentence, is that correct?
Correct.
How much time does Mr. Bastes need?
I think we're looking for 2 weeks. 2 weeks.
Does he need any more time than that?
I don't believe so. May I have one more?
Yes, of course.
Right. Okay. 2 weeks. 2 weeks is it, Judge. Thank you.
So let me go ahead and set that date, make sure everybody's available. We'll come back to that. Let me go ahead and do the plea colloquy first. So the plan then, Mr. Hollander, in order for Mr. Bastes to remain at liberty and to return for imposition of agreed sentence in approximately 2 weeks.
Yes, sir.
We'll just do the plea colloquy. The court will take no further action at this time. Mr. Ashby, I don't think it'll be an issue, but it always needs to be said in these deferred imposition of sentence situations. If for some reason Mr. Bastes did not return without adequate excuse, what is the state's position in that event?
In that event, Your Honor, the plea would stand. However, the terms of the agreement would not, the state would not be bound by those. We would essentially be in an open plea scenario where the court is presented to anything up to the maximum 5 years of department.
And Mr. Hollander, obviously, I know you're pretty thorough. You've discussed that with Mr. Bastes. I don't think it's going to be a problem, but it does need to be clarified.
I don't believe it'll be a problem.
Right. But we just need to set that straight so that he understands the importance of returning as agreed. All right?
And Your Honor, I think you have a plea date, 2 weeks out of June 11th at 9:30. I know from how my calendar is updated.
How many cases on that date, Madam Clerk? We will have done the plea colloquy, so it would not be long. Looks like June 11, that's a Friday at 9:30.
Yes, Your Honor.
11.
But we will have done the plea colloquy here. Is that suitable to Mr. Bastes and both sides, Mr. Hollander, June 11 at 9:30?
Yes, Judge, that's fine. 9:30
If-
on the 11th.
If he needed a little more time than that, I would be willing to grant it, but, because I know sometimes, you gotta get everything in order, but if he doesn't need it, then we can go with that date.
Yes, sir.
He doesn't need additional time?
I don't believe so. That's almost
Okay.
3 weeks. It's still in-
Oh, is it? All right, I
Yeah.
wasn't counting, but, all right, very well. Mr. Bassis, please raise your right hand to remain seated, be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, whole truth, and nothing but the truth?
Yes, I do.
Thank you, Mr. Bassis. Please lower your hand, please answer the state's questions.
Thank you, Your Honor. Sir, could you state the name and date of birth for record?
Thomas William Basson, January 19th, 1967,
There were the last 4 digits of the social security number.
2261.
Have you ever been known by any other names or aliases?
No.
Where were you born?
Minneapolis, Minnesota,
How far did you go in school?
11th grade.
Can you read, write, and understand the English language?
Yes.
Are you under the influence of any drugs or alcohol?
No.
Are you taking any medication?
None.
Are you suffering from any mental condition or disorder?
No.
Do you understand why we're here today?
Yes, I do.
Sir, in 20 CF 172, you've been charged in a one-time information with the following charge. Count 1, driving under the influence causing serious bodily injury. A third-degree felony punished up to 5 years in the Department of Correction. To that charge, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
So do you understand that driving under the influence is an enhanced offense, meaning if you're convicted of this offense in the future, you receive more jail or prison time or a higher fine? Do you understand that a third driving under the influence can be charged as a felony?
Yes.
Do you understand that by entering this plea, you're waiving your right for a trial by jury?
Yes.
Do you understand you are also waiving the following rights? Your right to have a jury determine your guilt or innocence, your right to see and hear the state's witnesses testify and have your or question with, your right to subpoena, call your own witnesses to submit evidence on your behalf, your right to testify in your own defense or to remain silent, and your right to make the state prove the charges against you beyond a reasonable doubt. Do you understand, sir, that you're waiving all those rights?
Yes.
Counsel, reserve any matters for appeal?
None.
Mr. Baskey, do you understand that you're giving up your right to appeal all grounds except what this court can hold this sentence? So I'm showing you your source, you have the opportunity to read this with your friend.
Yes, I have.
Showing you here shows you scored a total sentence point of 96 with a lowest permissible prison sentence in month of 51. So do you agree that this score sheet is accurate?
Yes.
Also holding a plea of guilty or no contest to criminal charges form. Or do this form front and back?
Yes.
That's your signature in the back and says defendant's signature.
Yes.
Your signature tells me that you read and understood the right to listen on this form. Did you in fact read and understand the right to listen on this form? Yes. Any questions about the plea form at the time for your attorney?
No, sir.
Sir, other than what is contained in the plea form or what we just discussed on the record, has anyone promised you anything in exchange for this plea?
No.
Are you entering this plea of your own free will?
Yes.
Are you being forced or threatened by anyone?
No.
Are you pleading because given your options, you believe that this plea is in your own best interest?
Yes.
Sir, do you understand there is no guarantee that you will be able to terminate this probation early?
Yes.
Are you satisfied with the advice and counsel of your attorney?
I'm sorry?
Are you satisfied with the advice
Yes,
and
I am.
counsel of your attorney?
No.
Has he done everything you've asked and answered all your questions?
Yes.
Have you gone over all the discovery in this case with your attorney?
Yes.
Have you had sufficient time to consider the offer and charge? Whether you want to accept this offer or what the trial will be? Any more time to speak with your attorney? Are you aware of any physical evidence that can be tested for DNA to exonerate you? Do you understand, as a result of this plea, no physical evidence can be tested for DNA?
Yes, I understand.
You understand that if you're not a U.S. citizen, you may be subjected to deportation or removal as a result of this case?
Yes.
You understand that if you're deported as a result of this case, it will not be a basis for withdrawal? You need any additional time to discuss this with your attorney?
No.
So if the offense which you are pleading is a sexually violent offense or a sexually motivated offense, or if you've been previously convicted of such an offense, this plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence. You understand this one?
Yes.
Sir, you discussed you are attempting to enter your plea today, but delay sentencing until June 11th at 9:30.
Yes, sir.
You understand that you are to return to this courtroom on June 11th at 9:30 to be sentenced?
Yes.
You understand that you failed to return to this courtroom on June 11th at 9:30 to be sentenced, the judge will not have to sentence you as agreed.
Yes.
You understand if you fail to return to this courtroom on June 11th at 9:30, the plea will stand, and the judge can sentence you to any lawful sentence up to and including the maximum sentence of 5 years in the Department of Corrections. You understand that if you are arrested in between now and your sentencing date, that the plea will stand, but the agreed upon sentence will be voided, and the judge will not have to follow the agreement.
Yes.
You understand that if you're arrested between now and your sentencing date, that the judge can sentence you to any lawful sentence up to and including the maximum sentence, which is 5 years in the Department of Corrections.
Yes.
Understanding all of that, do you still wish to enter this plea today?
Yes.
Counsel, do you stipulate to a factual basis of any of the purpose of the plea? Stipulate to both. That's a kind of please report.
Thank you.
Now we have a score sheet and plea form now, or do you want to wait?
I'll take that now. Mr. Hollander, any other comments for clarifications or requests?
No, sir. You covered.
All right. Now, I don't see any other entries on the criminal history, Mr. Ashby.
Sorry, Your Honor.
I don't see any other entries on the criminal history for Mr. Bastis. I thought I heard the state reference a second or third DUI. Did I not hear that correctly?
No, yeah, a third DUI will be charged with felony. It was just informing him of the answer to the DUI.
Right, but this would be a first.
This is his first DUI.
Okay.
First one.
All right. But you were referencing a third. That's just
Enhanceability of the DUI charge.
okay. But it doesn't look like it's in any way applicable here. Okay. All right.
Correct. And I will be preparing an order for the defendant to remain on bond, pending sentence.
Mr. Bastis, it appears you have no criminal history, and I know this is a difficult decision in this situation with this charge and with no prior history. Have you had enough time to speak with Mr. Hollander, as well as I believe maybe your significant other who's in the audience?
Sure.
And do you believe this is in your best interest then? Is that
Yes,
your
sir.
final decision?
Yes, sir.
All right. At this time, based on the plea colloquy, I will find that it is freely, voluntarily, intelligently made with advice of counsel. And the court will apply the plea agreement as announced, provided that Mr. Bastis, as I expect will occur, returns as promised. Otherwise, then that could change. But I don't think that will be an issue. At this point, I will take no further action, and we will return on June 11 at 9:30, I believe was announced, for imposition of sentence, which provided that the requirements are followed of appearing on that date and having no new law violations, the plea agreement would be approved on that date.
And I'll get the credit card.
Yes, we'll need to announce that. Any other clarifications at this time?
Nothing to say, Your Honor.
All right, thank you for resolving your case, Mr. Bastis, and we'll give you time to get everything in order, and we'll see you back on that date. Have a safe trip back. We'll defer on the prints until the later date.
Okay.
Do you want to give him a copy of his court date?
I will.
All right. Madam Clerk, the only thing I'm going to sign at this time is the plea form.
That's fine, because we give the court sheet back to the state.
All right. So this can be returned to the state. Here is the plea form. All right. Are we ready to address Owen Onfroy? Mr. Verderamo may have stepped out.
He did, he just stepped out.
All right. Is he nearby, Mr. Verderamo, or is he away? Could we check? All right. I just, well, we set the plea date, so that was fine. And that was a correct date? All right, let me, Mr. Samato, Ms. DeCaro, what are you here for? Which one? All right. We can address that now if you wish.
This is here for the calendar and all that.
All right. All right. Hello, sir. Welcome back. Thank you. Please be seated.
The issue that we have sent off is that Mr. Lady has
So, Ms. McCarroll, welcome. What do you wish to do today, Mr. Samato?
I'd like to administer the policy at 47 weeks, not at any point being part of the sentence. I would like to treat this as an completed court sentence, understanding that restitution is made this day to
Ms. McCarroll, what's your understanding?
Yes, our understanding is that the state is in agreement to what is the agreed upon long restitution of 30,000 cases by the state. What's not to say at that point, then it's considered.
All right. So at this point, we need to do the plea colloquy. Is that correct? All right. And Ms. McCarroll, you're free to sit next to Mr. Laley if you wish, or stand, however you're more comfortable. All right. Hello, Mr. Laley. Please raise your right hand and be sworn. Madam Clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you, sir. Please be seated and answer the state's questions, please.
Sir, I'm going to ask you to say your full name for the record.
Richard Levy.
Please take that microphone going. Go ahead.
Richard Levy, Jr.
What's your middle name, sir?
Dominic.
Okay, my information, I have you charged with Richard Vincent Lady.
That's my confirmation. So,
Okay, so you go by Richard Dominic?
I honestly go by Richard Levy. Yeah, Richard.
Please, you have gone by Richard Dominic Lady, Jr., so Richard Vincent Lady.
Correct.
Can you spell your last name for the record?
L-E-L-I.
Mr. Lady, what is your date of birth?
970.
And what is your social security number?
0546891.
Have you ever gone by any other name or given law enforcement a different name other than that?
No, no.
And where were you born, sir?
Staten Island, New York.
And how far have you gone?
I have a degree in college. 1 year credit in college.
Is it safe to say you can read, write, and understand the English language?
Yes.
Are you currently under the influence of drugs or alcohol at this time?
No.
Are you currently taking any medication?
No.
Are you suffering from a mental condition or mental disorder?
No.
Do you understand why we're here today, sir?
Yes.
Mr. Whaley, you were charged in case number 2019-1648 with 4 counts. Counts 1 and 2 involve securities fraud, which are both third-degree felonies. The first one occurring on or about October 27, 2015, here in Collier County, Florida. To that charge, sir, how do you wish to plead?
Guilty. No contest.
Which one?
No contest.
Sir, count 2 is also securities fraud, occurring on or about November 2nd, 2015, here in Collier County, Florida. To that charge, how do you wish to plead?
No contest.
Count 3 is a second-degree grand theft. It's a second-degree felony here in Collier County, Florida. It occurred on or about, between October 27, 2015 and November 5th, 2015. To that charge, sir, how do you?
No contest.
Mr. Whaley, you were originally charged with scheme to defraud. Do you understand that pursuant to a plea agreement, the state will not process that?
Yes.
So that scheme to defraud was also a second degree felony with a maximum penalty of 15 years in Florida. Do you understand that?
Yes.
The second degree grand theft is a second degree felony with a maximum penalty of 15 years in Florida state prison. Do you understand that?
Yes.
And securities fraud has a maximum penalty of 5 years in Florida state prison.
Yes.
Had you gone to trial in this case, sir, the maximum penalty?
Yes.
You understand that at this time, sir, this is an open plea. promises to you based on the fact that you have a position that you're trying to set. Okay?
Yes.
And Mr. Samala, excuse me interrupting, but that condition is what?
Restitution.
And it was an agreed amount, is that correct?
Yes, sir, they agree.
So there is a condition to the state's side of the bargain in the plea agreement, and that is that restitution in the amount of $30,000 be paid prior to the next court date that's going to be set.
Yes, in the victim's hands.
Okay. In the event that that does not occur, then the plea will stand, but each side will be free to argue for any sentence appropriate under the law and the facts. Is that, Ms. DeCaro, your understanding? And that could be significant here because I see there are 2 second-degree felonies and 2 third-degree felonies. So the range on that, I don't know what the score sheet shows, but is potentially quite large.
Yes, and we're now passing one of the
All right, so I just wanted to make sure before we go any further that everyone's on the same page on this. Is that basically correct, Ms. DeCaro?
Yes, Your Honor.
Very well. Go ahead, Mr. Samato, thank you.
Sir, you understand that by entering this plea, you're waiving your right to a trial.
Yes.
You also understand that you're waiving your right to have the jury determine your guilt or innocence.
Yes.
You're waiving your right to see and hear the state witnesses testify and have your questions.
Yes.
You're waiving your right to subpoena and call your own witnesses and submit evidence on your own behalf.
Yes.
You're waiving your right to testify in your own defense, which remains silent. Do you understand that?
Yes.
Do you understand that by entering this plea, you're also waiving the right to have the state prove these charges against you beyond the
Yes.
Mr. Carroll, have you reserved any matters for appeal?
No.
Mr. Whaley, do you understand that by giving up your right to appeal on all grounds, giving up your right to appeal on all grounds, except whether this court can impose the sentence?
Yes.
Mr. Whaley, have you reviewed the sentence report?
Yes, I have.
And do you believe that the score sheet is accurate?
Yes.
Because I will present one to the court as that. Mr. Whaley, have you reviewed the plea form? Plea form is this document that was given to me a moment ago. It has 2 sides.
Excuse me, everyone is required to be masked in the courtroom.
Yeah. You need to go outside the courtroom. You know,
All right, sorry for the interruption. Mr. Laley has signed the plea form in open court.
Mr. Lilly, it is observed in signing the plea form in open court. You have an opportunity to read and sign the form. And you understand all the rights and that.
Yes.
Do you have any other questions for your attorney about this plea form or this plea?
No.
Other than what's contained in this plea form and what we just discussed on the record, and the promise to me. Are you entering this plea of your own free will?
Yes.
Are you being forced or threatened by anyone?
No.
Are you pleading because given your options, you believe that this plea is in your own best?
Yes.
Are you satisfied with the advice of counsel?
Yes.
Has Mr. Farrow done everything you've asked and answered all the questions?
Yes.
Counselor, you reviewed all the discovery, evidence, and depositions in this case for your client.
Yes, I have.
Is there anything that you wanted to review that you're not able to review, Mr. Bailey?
No, sir.
I am unaware of any physical evidence that can test for DNA in this case. Mr. Farrow, would you agree?
Right.
Mr. Whaley, do you understand that as a result of this, plea, no physical evidence will be tested?
Yes.
Mr. Whaley, do you understand that you're now a U.S. citizen, you may be subjected to removal or deportation as a result of this plea?
Yes.
And do you understand that if you were deported as a result of this, you will not be a case of fraud?
Yes.
If the offense to which you're pleading is a sexually violent offense or sexually motivated offense, or if you've been previously convicted of sexual offense, This plea may subject you to involuntary civil commitment as a sexually violent predator constitution of your sex. You understand this point?
Yes.
Counsel, do you stipulate to a factual basis and venue for purposes of the plea?
Something like,
And counsel, based on the fact that your client has a previous felony conviction, there is no need for this.
yes, maybe fine.
Your Honor, at this time, the state would ask the court to take position with the court file and the kind of data with the court please.
Mr. Samato, if and when Mr. Laley satisfies his condition of restitution, what would be the agreed terms?
We can put that on the record, Judge, but I'm afraid that may create
All right. Any issue with that, Ms. DeCarroll?
Your Honor, I think it would be behoove to have an accurate record of what Mr. Lilly's understanding of today's agreement is today, and then he's entering a plea to that agreement subject to him satisfying the condition of restitution.
Mr. Samato, what's the state's concern with putting that on the record at this time?
I believe that the appellate court will not punish them for the Constitution. So if I put an offer on the record and indicate to the court that this is the record, or this is the plea offer you should receive, and Mr. Laley doesn't satisfy with that deal, and the court ultimately does treat this like an open plea and sentences him to something more severe, then the appellate court will treat that as an unfair.
So that apparently is something unique to the restitution element based on the case law.
And so the courts have agreed that the trial court cannot punish someone who may not satisfy their restitution.
However, the parties have had negotiation,
And it's all in writing.
and there's an understanding if the restitution is satisfied timely as to what will occur.
And that's why the state feels that if we make a recommendation.
That's fine. In the event that restitution is not timely satisfied, then it will be an open plea.
That's right.
All right, Ms. DeCarroll, you have Mr. Samato as an officer of the court indicating that there is confirmation.
Your Honor, may I speak for a second?
Yes.
You know, are you more talking count 4 now, or you want?
Yeah, we'll do that.
So the state is announcing a null pros on count 4, is that correct? Ms. DeCarroll?
Yes, that's my understanding. I was referring to the court in regards to allocating the agreement's restitution.
Right, so at this point, based on the authority referenced by Mr. Samato, the parties have an understanding, it is memorialized. I will not require that to be placed on the record at this time. However, it's been memorialized should and when Mr. Laley timely fulfills his restitution commitment. Otherwise, it will be an open plea. And when do the parties agree, or when did Mr. Laley request to return for imposition of sentence?
Yes, at least a month. He does have to swipe out.
One moment. Looking at plea dates, I have a July 16 Friday at 9:30. Is that too far out for the state? Does that give Mr. Laley the time he would request?
Yes, Your Honor, thank you.
Very good. Ms. DeCarroll, any conflict with that date? And Madam Clerk, how many cases on that date?
Just one, Judge.
Okay, and we already have the plea policy done, but if it were to be an open plea, then it might require hearing it on some other occasion. I'm not sure. We'd have to address that there, because if it's going to be a significant. Now, if you'd rather set it, Mr. Samato, in an abundance of caution for a date that would allow time for either a plea agreement or a plea to the bench, I can do that now.
Well, I was actually going to ask the clerk for that, because you said it sooner, the understanding that this would just be sent on basically an agreed upon plea. And then if we need to set it out, then we're not setting it too far out.
Well, the only thing I think I heard Mr. Laley needed time to do the restitution and to return.
He does reside in New York.
Right, and I thought I heard the end of June.
Right.
So
The court wasn't doing anything else.
I can look for a date if you need to have it before July 16. The next regularly scheduled plea date was July 16.
That's fine. Well, we can,
All right, we'll address it then on July 16. That gives Mr. Laley a little added time then.
what time?
That would be at 9:30. So at this time, I will find the plea is freely, voluntarily, intelligently made with advice of counsel. And the court will then resume with this case with imposition of sentence or an open plea, depending on what occurs on the restitution. Anything else that should be clarified for either side or the clerk?
I just need an order for him to remain on the line.
Yeah, so Ms. Becaro, if you can just do that here in court before we leave. Officer Harrison, any updates?
It's negative.
All right. All right, so there was a warrant check apparently, but it is not applicable to Mr. Laley. So,
I would just ask that Mr. Laley make the restitution payment for you.
and are there any specific details on how and where or to who that restitution is?
Essentially, our victim lives here locally.
So the parties will confer about that. All right, thank you, Mr. Laley, for resolving your case, and we'll give you a copy of your court notice and see you in July.
Thank you, Your Honor.
Very good. Mr. Verderamo has returned the Onfroy matter, 19 CF 1127. Morning, Mr. Onfroy. Welcome back. And Mr. Verderamo for the defense, Ms. Mason for the state. Any comments, Mr. Verderamo?
Derek Borderell on behalf of Mr. Onfroy, Mr. Onfroy is our chief of state driving. Terms are adjudication of guilt. 36 months Department of Corrections, credit for 2 days. And a fine of $25,000 for that. 6 months guideline revocation. And a cost, I'm not sure if they're fine, they're out of control.
There's not, just court costs and $100 cost of prosecution.
Those are the terms.
What are the court costs, Madam Clerk?
$415.
Okay. When will the sentence begin?
Today.
All right. Any other clarifications for the state or the clerk?
Your only the 3-year sentence has a minimum per statute.
Was that understood, Mr. Verderamo?
And Judge, permission for his son to come to work is possible for him to come in.
How old is his son?
He is 21.
All right. And will he have a mask?
Of course.
Okay. Yeah, that is granted.
Thank you.
It's a 3-year minimum mandatory.
Mr. Onfroy? Mr. Onfroy, have you had sufficient time to speak about this important decision with your counsel? You'll need to verbalize an answer.
You need to answer out loud. You need more time to speak when you're at the time at all.
All right. And at this time, do you believe it is in your best interest to accept this agreement as opposed to having a jury trial tomorrow on this case? Okay. If you can answer that.
Let's just sit down.
Yeah, if you can have a seat. If you can just speak out loud, please.
Answer the questions out loud.
Are there any competency issues, Mr. Verderamo?
Absolutely not.
Okay, I understand. Is it, are there any language barriers?
No.
Okay. So, Mr. Onfroy, you're thinking clearly today and understand everything I'm asking you?
Answer out loud, yes.
All right. Do you understand the plea agreement? Yeah, you can just speak up if you can. All right. And do you prefer to have this agreement and the certainty it brings than to have the risk of the jury trial and, if found guilty, a potential sentence different from the agreement? Is that what you wish to do and accept the agreement today? All right. And I see some of your family members are here. Have you not only discussed with Mr. Verderamo, but if appropriate, have you discussed with them this very important decision? Okay, and at this time, you're ready to make a final decision today, understanding that it wouldn't result in you going into custody on this charge today? All right, I appreciate that it's a difficult thing to decide. At this point, then please raise your right hand and be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you. May lower your hand, and please try to speak up if you can so that we can hear you. Thank you. Please answer the state's question.
Would you state your full name and date of birth? Can you state your full name? Yes, sir. And Mr. Rockford, what's your birthday? What are the last 4 digits of your social security?
If you remember.
Okay. What are the last 4 digits of your social security number? Have you ever been known by an alias or any other name? Where were you born?
Jamaica.
And how far did you go in school?
High school, 9th grade.
Okay, are you able to read, write, and understand the English language?
Yes, ma'am.
Are you under the influence of any drugs or alcohol today?
No, ma'am.
Are you prescribed any medication?
No, ma'am.
Are you suffering from any kind of mental condition or disorder?
No, ma'am.
You understand why we're here today?
Ma'am.
In case number 19 CF 1127, you're charged with 1 pound of trafficking in cannabis, 25 pounds or more. That's a first-degree felony. It is punishable by up to 30 years in state prison. To that charge, you plead guilty, not guilty, or no contest. And you understand, Mr. Envoy, that by entering your plea today, you understand that you're waiving your right to a jury trial. And at that trial, you would have had the right to see and hear the state's witnesses testify and have your lawyer question them. You would have had the right to subpoena your own witnesses to get evidence in your own behalf, the right to testify in your own defense or to remain silent, the right to make the state prove this charge beyond a reasonable doubt, and the right to have a jury determine whether you were guilty or innocent. You understand that by entering your plea today that you are waiving all of those rights and there will not be a jury trial. Counsel, under your zoning matters to appeal?
No.
Mr. Rockford, do you understand that you're giving up your right to appeal anything other than whether this court has the jurisdiction to impose this sentence? Right.
Yes, ma'am.
Mr. Rockford, I'm showing you a plea of guilty or no contest form. It's front and back. There are 2 signatures here on the back. Are those your signatures?
Yes, ma'am.
And does one of those signatures indicate that you've read this form or that it's been explained to you and you understand all the rights contained in it?
Ma'am.
Did you have a chance to discuss this form with your attorney?
Repeat that.
Did you get a chance to discuss this form with Mr. Bergeramo? And did you have any questions about it?
No.
Did you say not much?
No.
Okay, no questions? Okay. I'm also showing you your 3-page score sheet. Do you recognize this? And your score sheet shows that the total of 56 sentencing points. The lowest permissible prison sentence is 21 months in state prison. And the maximum sentence you receive is 30 years in state prison. And do you agree that this score sheet is accurate? And for the record, the score sheet shows that you have no prior criminal history. Is that correct? Now, Mr. Envoy, do you understand that according by statute, this particular charge carries a 3-year minimum mandatory prison sentence? Do you understand that? And what that means is that you'll have to serve 3 years in prison day for day, which means you wouldn't get any time off for like game time or time off for sentence for behavior or anything like that. Do you understand that? And is that your understanding of the plea? Are you satisfied with the advice and counsel of your attorney? Are you satisfied with the advice and counsel of Mr. Bergeramo? Has Mr. Bergeramo done everything you asked and answered all of your questions? Has he discussed this case with you in entirety, including any possible offenses that you may or may not have? And Mr. Bergeramo, do you feel discovery this case as well?
Yes.
Mr. Rockboy, is there anything about your case that you wanted a chance to review that you have not had an opportunity to review? Are you entering this plea in your own free will? Do you feel that entering this plea is in your best interest? Has anyone promised you anything or threatened you or forced you or coerced you to get you to enter this plea?
No, ma'am.
Do you understand, Mr. Envoy, that if you were not a United States citizen, you may be subject to deportation or removal as a result of this plea? And then if you were deported or removed as a result of this plea, it would not be a basis to withdraw your plea. You understand that? And do you need any additional time to discuss possible immigration consequences with your attorney? Do you need any additional time to discuss possible immigration consequences with an attorney? Your Honor, I'm not aware of any physical evidence to be tested for DNA that can potentially exonerate the defense. Counsel, do you agree?
I agree.
Mr. Envoy, do you understand that as a result of your plea today, there is no physical evidence in this case that will be tested for your DNA? Do you understand that if the offense to which you were admitting was or pleading was sexually violent or sexually motivated, or if you had previously been convicted of such an offense, this plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence. Do you understand that, warning? And counsel, do you see that the court on the court file and the affidavits contained during those sexual activities today?
Those situations.
And that it is processed while you're on court.
Correct.
Right, this time the state will ask the court to take judicial notice of the court file in 19 CF 1127, return of the plea to the court, and meeting for the plea form and the solution.
Mr. Verderamo, any additional defense clarifications or requests?
Nothing good.
Based on the plea agreement, the plea colloquy, the plea of no contest, and the arrest affidavit facts in support thereof, the court finds that the plea is freely, voluntarily, intelligently made at the advice of counsel. Court accepts the plea agreement. Under that agreement, there is an adjudication of guilt on the charge, a 36 months Department of Corrections minimum mandatory sentence, credit 2 days as agreed, statutory $25,000 fine converted to civil judgment as agreed, 6-month driver license suspension or revocation per statute, court costs $415, prosecution $100. Any other clarifications to be addressed?
No, Your Honor.
Thank you for resolving your case, Mr. Onfroy. There is no supervision to follow, so once he does the sentence, it will be done.
Yes, sir.
Thank you. Please step over here for the prints. I'll wait a moment for the bailiffs. All right, I believe that completes that matter. There's one case remaining for the trial call. Mr. Woodley Pierre Louise, Mr. Zonas Defense Counsel, Mr. Ashby for the state.
Yes, Your Honor, that's also a case.
All right, 20 CF 0639. Welcome back, Mr. Pierre Louis. You can be seated, thank you. Mr. Ashby, what's the, well, first of all, Mr. Zonas, what is the status?
Your Honor, Mr. Pierre Louis, no drug, that he's not going to do no contest. Terms of the agreement are as count 1, 24 months probation, $290 plus investigation court costs, 1 year DL revocation, an 8-year, 8-hour driver's license course, and counts 2 and 3 would just be adjudication time served, and he does have 90 days.
Is that going towards probation? Or 90 days credit time served or not?
No, it would, yes, it'd be counts 2 for everything.
Okay, so it's just 24 months probation, 8-hour driver course, and 1 year revocation?
I'm counting like all the adjudication.
Okay, got it.
With no objection again, and they're trying to obtain a hardship.
Any state comment on that?
No objection to the request for hardship, Your Honor.
Okay. The court will note on the judgment and sentence that the court authorized a business purpose or hardship license. Mr. Pierre Louis, any questions about the plea agreement?
No.
Okay. Having conferred with your attorney, is it your decision to accept this plea agreement at this time as opposed to having a trial tomorrow?
Yeah.
Please raise your right hand. You can remain seated and be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you. May lower your hand. And Mr. Zonas, could you just pull the microphone a little closer to him there? And please answer the state's questions.
Thank you, Your Honor. Sir, if you please state your name and date of birth. Lewis. Sir, what are the last 4 digits of your social security number? Have you ever been known by any other names or aliases? No. Where were you born? How far did you go in school? Can you read, write, and understand the English language? Are you under the influence of any drugs or alcohol? No. Are you suffering from any mental conditions or disorders? No. Are you taking any medication? No. Do you understand why we're here today? Sir, in 20 CF 639, you've been charged in a 3-count information with the following charges. Count 1, fleeing and eluding at high speed or with wanton disregard. A second-degree felony punished by up to 15 years in the Department of Corrections. That charge, how do you wish to plead? Guilty, not guilty, or no contest? No, not guilty. I mean, no contest. You ever no contest, please? Is that correct? As to count 2, driving while license suspended or revoked, a second-degree misdemeanor punished by up to 60 days in the Carter County Jail. That charge, how do you wish to plead? Guilty, not guilty, or no contest? And as to count 3, resisting an officer without violence, a first-degree misdemeanor punished up to 1 year in the Carter County Jail. For that charge, how do you wish to plead? Guilty, not guilty, or no contest? No contest.
They're very similar, but quite different.
No contest to the charge. All right, sir. So you understand that driving a license suspended or revoked is an enhanceable offense, meaning if you're convicted of that offense in the future, you receive more jail or prison time or a higher fine. Yeah. You also understand that a third driving a license suspended or revoked can be charged as well. So you also understand that based on the nature of these charges, it is possible that the Florida Highway Safety Motor Vehicles may habitualize your driver's license. So, do you understand that? Sure. Understanding all that, do you still wish to answer this plea today? No contest. I mean, no. Understanding all that, do you still wish to answer this plea? Yes. So do you understand that by entering this plea, you're waiving your right to a trial by jury? You understand you're also waiving the following rights. Your right to have a jury determine your guilt or innocence, your right to see and hear the state's witnesses testify and have your lawyer question them, your right to subpoena, call your own witnesses and submit evidence on your behalf, your right to testify in your own defense or to remain silent, and your right to the state prove the charges against you beyond a reasonable doubt. You understand that you're waiving all those rights by entering this plea today. Yes. Counsel, you reserve any matters for appeal?
I have not.
Mr. Luis, you understand that you're given your right to appeal all grounds, except whether this court can impose this sentence. Good. Sir, have an opportunity to review your sources with your attorney? Yeah. Holding here my hand to show you score a total sentence point of 26.2 with a lowest permissible prison sentence and month of 0. Do you agree that this score sheet is accurate, sir? Yes. Also holding a plea of guilty or no contest to criminal charges form. Now review this form front and back with your attorney. Is that a yes? Yes. Is that your signature on the back or it says defendant's signature? Yes. Your request, your signature tells me that you read and understood the rights listed on the plea form. Did you in fact read and understand the rights listed on the plea form? Your question about the plea form at this time to your attorney. Sir, other than what other was contained in the plea form on what we just discussed on the record, has anyone promised you anything in exchange for this plea? No. Are you entering this plea of your own free will? Are you being forced or threatened by anyone? Are you pleading because given your options, you believe that this plea is in your own best interest? Yes. You understand that there is no guarantee you will be able to terminate your probation early? You did that for. Well, you could petition the court You can ask the court to, at the halfway point, you can ask the court to let you off probation early. However, at this point, there's no guarantee that that will occur. You understand that? Is that it? I'll help you. Good. All right. Understanding that, you see what that is today. Strongly, are you satisfied with the advice and counsel of your attorney? Good. Has he done everything you've asked and answered all your questions? No. Have you gone over all the discovery in this case with your attorney? Have you had sufficient time to consider the offer, the charges, whether you want to accept the state offer or go to trial with your attorney? No. Do you need any more time to speak with your attorney? No. So I'm aware of the physical evidence that can be tested for DNA to exonerate you. You understand, as a result of this plea, no physical evidence will be tested for DNA. You understand that if you're not a U.S. citizen, you may be subjected to removal or deportation as a result of this plea. Yeah. You understand that if you're deported as a result of this case, it will not be a basis to withdraw this plea. Yeah. You need any additional time to discuss this with your attorney. No. So if the offense to which you are pleading is a sexually violent offense or a sexually motivated offense, or if you've been convicted of such an offense, this plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence. You understand this warning, sir? Counsel, do you stipulate the factual basis of the purpose of the plea?
I do.
And the state counsel please report.
Mr. Zonas, any other defense requests?
Nothing further, Your Honor.
There are no competency issues affecting the entry of the plea, is that correct?
No.
And is there any law enforcement known objection to the plea agreement, Mr. Ashby?
No, Your Honor.
Based on the plea agreement, plea colloquy, the pleas of no contest, and the arrest affidavit facts, the court accepts the plea agreement as agreed. Adjudications of guilt, counts 1 through 3, counts 2 and 3 are time served. Count 1 is 24 months regular supervision. Reporting today, Mr. Zonas.
Yeah, that's fine, Your Honor.
And is there any need to transfer supervision anywhere?
Not at this time.
Additionally, $292 investigative costs, court costs, Madam Clerk.
448, sir.
So ordered. There are no, prosecution costs 100. Any objections, Mr. Zonas? Any monetary amounts?
No, Your Honor.
Statutory 1-year driver license suspension. Court authorizes business purpose or hardship license if otherwise eligible with domestic, Department of Motor Vehicles. 8-hour driver license improvement course to be done during the course of the supervision. Any other terms to be announced? Thank you for resolving your case, Mr. Lewis Pierre. Please step over here. That leaves, I believe, one matter, the AVIG ruling. I'm going to take a 5-minute recess and then come back with that.
I had a quick update with that.
All right. Oh, all right. All
We
right.
can do it after the break.
Well, let's do it before the break. Yeah,
Yes.
let me address the AVIG case. Do we need to wait a moment for
Yeah,
Mr. AVIG?
yes.
All right.
I just didn't know if we were gonna go back and grab your stuff. and then-
Well, if there's something I need to look at, then I may want to do that.
Not earth shattering, but I want to.
All right. 20 CF 1202, Mr. Day for the defense, Mr. Ashby for the state. We'll take a pause while we wait for Mr. AVIG. Yes. Are you going to be elsewhere? All right. I may want to speak with you briefly after this is over. We'll call you. No, not necessarily. We can call you. So I've been handed by Mr. Day the Jennings decision, 22/7/3/708. Await Mr. Abbott. All right.
Like Mr. Abbott before the court.
Okay. Welcome back, Mr. Abbott. Please be seated.
So when we left off last, Judge, we discussed the issue of the requirements of reporting any contact with law enforcement. Advised the court that there's no case on point with that particular issue. I went back and double checked, still have not found one, but I did want to bring this one case to the court's attention. It was the only case that discusses this issue, but the issue on appeal was not our issue, but I want to provide it to the court.
Okay.
It was the Jennings versus State
22/7/37/08/209.
Right out of the 20th Judicial Circuit, I
Yes.
see.
The defendant was violated for two issues. One was for a civil infraction, and two was for not putting in his reporting report, his contact with the law enforcement, which is the civil infraction. So the issue that went up on appeal primarily was the civil infraction, but when the offender was, and they do discuss, it was also violated the failure to report truthfully contact law enforcement. So there were those two issues. It was reversed and remanded on the infraction issue, and they left the other issue open. But the issue on appeal on this was not whether or not we could violate the probation simply by coming in contact with law enforcement and failure to truthfully fill out that monthly reporting form. So the issue that we argued the other day, just to make it clear again, first of all, the standard condition of probation does not make it a violation of probation to come in contact with law enforcement. The violation is to commit a new criminal offense. The monthly reporting form from the Department of Corrections asks, have you had contact with law enforcement? And if they answer no to that, it is the Department of Corrections' position that they can violate the offender. Our argument for the court, which is still unanswered anywhere, is because it's not a standard condition of probation, simply having contact with law enforcement. The fact that DOC chooses to ask that question is not legally sufficient to violate probation to get contact. The only violation authorized under the statute is a new criminal law violation.
So how does this case assist your argument?
It doesn't. It doesn't assist me, but I don't think it hurts me, but I want to make sure I brought it to your attention.
Right. Well, what in particular are you referencing in this case?
Well, it was the failure to truthfully report the probation his contact on a civil infraction. And the second district seemed to suggest in the very last part of that opinion, it said, Jennings violation condition 1, standing alone warrants the revocation of his probation. In other words, the second district is saying, hey, if you get stopped for a civil infraction, you have to tell law enforcement or tell the department about that when you report. Do you see that provision, Judge?
Where are you reading from?
The second, very last paragraph of the opinion. The very bottom where it says, Mr. Jennings violation of condition 1, standing alone warrants the revocation of his probation violation. You see that sentence?
Okay.
So the inference from that is if a probationer comes in contact with the police for even a civil infraction and they lie about it in the report, that would constitute a violation. But that's not the issue of appeal that was addressed. Our issue is not. But I mean, I could see the court saying that this case stands for the proposition. You have to tell probation, even if you come in contact with someone. And it's not a crime.
Mr. Ashby, I don't believe that the court received in evidence the reporting form.
No.
Right. It appears undisputed that reporting form makes a question about any contact with law enforcement.
Yes.
Mr. Day is saying that the standard conditions of probation do not reference that. Do you disagree with that?
I looked at the standard and it does not. They do have the reporting form and they ask them, did you have any contact with law enforcement? That contact on that form, the defendant, as the officer indicated, testified to the probationer, never told her that he had a contact with law enforcement, telling him that he was placed in handcuffs and placed in the back of the patrol car by the two officers that testified at the hearing.
Mr. Day, there is, I believe, a standard condition that says that all probationers must truthfully answer questions posed by probation.
Yes.
So why would this situation be any different than if the individual does not answer truthfully another question during the interview?
So my answer to that would be, Your Honor, that I don't think that you can give probation officers the jurisdictional authority to determine whether to violate someone's probation simply because they don't ask any question that is not truthful. I think it would have to be a question to which either relates to probation or legal obligation of the offender. Let me give you an example. Let's say the probationer asks the probation officer asked one of the probation individuals an innocuous question about whether or not how many miles their car has on it, and the offender says 50,000, turns out it's 75,000. That'd be a lie. So could they violate someone's probation for a lie about something that's not related to a condition, an obligation of probation?
So your position is that the only way that someone can be found in violation for not being truthful in response to a probation question is if that question relates to one of the standard or specific conditions?
Absolutely. For instance, have they used drugs? Have they been at their house? Have they been hanging around felons? Have they been work like they're supposed to be? Have they been complying with their community control? I don't think it's just any question probation decides to ask, because that would result in theoretically an absurdity that someone's probation could be violated simply because they didn't answer truthfully some question, some random question that the probation officer picks out. Now, candidly to the court, if you look at these cases, 99.9% of them in Florida probably do involve a question about an obligation of probation. Have you used drugs? Have you committed a criminal offense? Have you drank alcohol? Have you complied by your terms of community control? There are very few situations where a question is asked that I've seen anyway that's outside of those obligations. Hence this question that DOC created on their form. This is not a legislative created form or court created form. It's a DOC created form that asks, have you come in contact with law enforcement? The statutory obligation is, have you committed the statutory violation, have you committed a new criminal offense? So that raises the question then, can someone really be violated for not answering truthfully a question that they're not obligated to comply with under the terms and conditions of probation? And that's all I'm suggesting hasn't been answered. And I didn't know if this case helped or hurt, but I wanted to make sure I provided support in case it swayed your mind one way or another. I didn't want to make sure you didn't know about it.
Thank you. Mr. Ashby, any other comment?
Your Honor, I would say in reading the case, it seems to stand for the proposition that if the probationer is asked if they had any contact with law enforcement, they have to answer that question truthfully. In head note 3 of the opinion, it states, thus, the trial court's finding that Mr. Jennings has violated condition 1 by failing to submit a full and truthful report was supported by competent substantial evidence. Namely, that he did not tell his probation officer that he had contact with a law enforcement officer when he was issued a citation, traffic citation. What we have in our case is substantially more. It isn't simply just a traffic citation. What we had was a defendant who was stopped by police, investigated, actually had handcuffs put on him, and was placed in the back of the patrol car. This isn't simply a traffic citation for improper lane change or running a stop sign. This was a criminal investigation involving narcotics. So I think based on this case, it would stand for proposition that the defendant was in violation, and that the court should find so.
What about Mr. Day's argument that to interpret it to questions such as contact with law enforcement that are not part of the conditions would lead to absurd or unfair results?
Your Honor, the question that I would argue that the questions about how you have any contact with law enforcement is related to probation. Contact with law enforcement often does lead to issues of people violating condition 5, committing new law offenses. If they are at, for example, a house that is being searched for search warrant, well, that's a violation for being associated with criminal enterprise or felony. They may not have been arrested at that scene, but having close contact with law enforcement officers while they were involved in that search warrant may very well be the basis. The intent is essentially to make the probationer be truthful if they've had contact with law enforcement. Even something as simple as a traffic citation. It's not a criminal offense, and which is stated to point out that even in this case, the case that in the Jennings case, that is not a criminal case that he was violated for. It was a civil traffic infraction, but he had contact with the officers all the same. And the courts have said it was competent and substantial evidence to find he had violated probation because he did not inform the probation officer of that contact.
Mr. Day, any final comment?
Just one other thing I wanted to point out to you, Judge, that that's the reason I provided the case. I understand this case could stand for the proposition here for their argument. However, it's important to note that what I raised was not on appeal for the second district. What the second district did say is, which is it's dicta, but it throws out relevance to our issue, They said, in the opinion, we understand how in preparing his monthly report, a person on probation for 2 serious felonies might overlook a traffic stop for running a red light. So I think this issue is out there right now, and it has not been addressed. I didn't want to lead the court to the conclusion that you could agree, Your Honor, with the state that this case stands for the proposition that there is a requirement that you report any question asked. But I would just ask everyone to caution themselves the facts. My argument was not on appeal before the second district. It wasn't you can just ask any question you want. And so but I did want you to have the case to the extent that it may.
All right, let's take a 15-minute recess. I do want to read the case carefully, and then we'll come back and I'll announce a ruling.
All right, court is in recess for 15 minutes.
Can't be here in 15.
This has been a lot of that.
Huh?
No. Oh, so you did it on time.
Senator Truancy question?
Man, I got time for this.
10:15 to 8:50.
It's crazy. What's the name?
Leanna Drum. We'll change our line back to 10:15.
The last name is what?
Drum. Snare drum, bass drum.
It's not on the Raymond document. No. So what's it? Well, why is she here?
You got any paperwork with you?
Okay, then you need to go down to the first floor and they need to tell you something because you're not on the Raymond document
No.
this morning.
First floor, customer service.
It's DRUM, right?
Yeah. Snare drum, bass drum.
What's the
Yeah.
last name? Speaker drums, BURS.
I don't see her.
She's not on the docket. Not on my docket. No. Long as you're an escort and you're supposed to be here. Way early.
Maybe the case is dropped.
I don't have her on my docket.
What's the first name?
What's the first name?
Brianna.
Brianna.
Did you drop the case, Brian?
No.
I don't even see her.
Not your service.
Unfortunately, I don't have my paperwork.
Oh, that's not good. Unfortunately, yeah, probably a misdemeanor. A DV misdemeanor. And I think because you had the public defender that scheduled you a new court case, so the best thing to do is go upstairs to the public defender's office and like talk to them. Yeah.
Go to the fifth floor, public defender's office. Know who you are, find out who your public defender is. Talk to them.
Carrie Audrey.
What happened?
No.
Why are we on the way?
If your attorney is Carrie Audrey, your case number is 21 MM 804.
Good.
She heard us too.
Oh. Can we do like, what do you have in the morning?
I didn't have to do that.
That's too early. How about 10:30?
But it's still beautiful.
Yeah. Okay,
No,
thank
no,
you.
true.
Bye.
I like that. Okay, well, I'll say 2 little road rats. Yeah. You know what? All I'm gonna say is the rest of your life is gonna be crazy. When you got 2 of them the same age.
Yeah.
And you know what that means? They're gonna be doing everything about the same, not, of course, school activities, but they get older and they start doing
You're gonna have one that's bad and one that's good. You're gonna be like, what?
No.
You like your brother.
They're all gonna be good.
One of them gonna get in trouble. Let's just forgive it.
Okay. How
Or they could be like,
Lily Pierre, that kid,
oh, you know him?
we already plugged him out.
When?
About 30 minutes ago.
Oh, yeah. I don't think he wanted to plea out.
He is never gonna make that probation.
Of course not.
Never.
Well, that's why we have a
Because we have-
VOP doctor.
And his brother last week.
Really?
Yeah, Marley's.
Oh, dang. I don't know. I knew it was gonna be a good week. I knew we were not gonna have any problems. I'm so excited.
Oh, no. When we
trial.
talk to the judge, we're not gonna have any trial.
No.
I will say, you know what? Right now, we've got Tuesday, Wednesday, Thursday, Friday.
No, we don't. Wednesday and Thursday, we have stuff.
We do?
Yeah.
How much stuff?
We got stuff, we got long hearings and shit. Long
Okay,
hearings
Melissa's
and
getting
shit.
shit together.
Yeah.
Okay. Yeah.
Yeah.
Those that.
I think tomorrow is the only 3 days. Tomorrow and Friday.
Yeah, tomorrow and, well, for me, tomorrow and Thursday and Friday. So
Yeah.
that's pretty good. A big problem, to be honest, but, we don't want to get staff like that.
Yeah, so get.
Yeah. So I'm not saying anything on Friday.
But you know what, they say the second one is the everything is the one that talks to Mike.
Yeah.
So when I do, I'm gonna do the shop.
You ever done it yet?
Uh-uh.
Oh my God, I've done it and it's over with and
But I'm gonna schedule my second shop to be on Monday because I am not screwing up my weekend.
it's best to get it done on a Friday like I did and just,
I'm not screwing up my weekend.
yeah, but then what happens if you gotta be out there Tuesday? That way you have that weekend.
That's exactly what you're saying. You're gonna be out.
I'm gonna be out Tuesday, Wednesday, Thursday, Friday.
No, it doesn't take you out that long.
It will. I'm gonna have an adverse reaction.
That's a shame. I didn't know.
I don't feel right. I don't feel good.
I don't feel good. Feel lightheaded.
I thought you had your shot already. No.
No.
Oh
No,
my
I've had
God.
shots, but not this kind of shot.
Oh my God, it's been 6
I have
weeks
my
for me.
reads, my distemperament, and
Wow. I guess I was one of the lucky ones because you didn't do anything to me.
no.
Wow.
My bipolar shot, I've had that. I've been to DLC. I got my shot this week for my bipolar.
Oh man.
I'm on the shot.
Is this your first or second one?
Second.
Oh, okay.
Hey, when you go through the shot, there's a vial full of stuff this big. And you
I don't look at it.
just, no. And the needle's this long.
I don't know because I didn't look.
I'm just-
I'm not a
I think you better go check that. Well, I was compliment the food.
They have to be out
Yeah.
Yeah, Probably not in a doctor's office. Well, there was a bunch of cages in there. Well, maybe, I thought it might have been just a lab rat. What? Well, speaking of lab rats, one got loose. What? Speak that. And he's not running it. It smells like rat here. It does smell like smoked rat in here. Really up around that area, there is a, up around that area, there's a strong stench of smoked rat. Remember when we were farming? Lisa, go ahead, stop there. Lisa, you guys gotta hear those. You had that Corona pocket, you know, you did? Showing, what you have to do and everything, so let him do it, you know? He comes in this door and we're walking out of the hallway. It's business. Make sure you spray good, you got rat in there, you know? and so he opens the door, he swings the door, and he goes, yeah, it smells like wet rat in here. Smoke rat. As he's entering the door, he looks over the left and vomits on the bench. Oh, no! I'm still in the hallway, so you can't see me. I'm still in the hallway, laughing my ass off.
Oh, that's bad.
Oh, that was fantastic.
Oh, my God.
They're dying. Yeah. So, like, he was in here doing some work, it's still very cold anyway. So, yeah, for hours, sprayed it, so we almost lost them. Don't like smoke rat. Yeah.
Oh, no.
Great. Some of the shit we've done. Wonder we haven't gotten fired yet. It has no entertainment to hear about. I know. Hey, what'd you think of the text messages that came out? We read this whole issue and go, shit. I already have. What do you think of the text messages that came out this weekend? You want to work the fires? I'm like, okay. Not only do they got us doing 2 mandatory traffic stops. Yeah. You know, yeah, I was already busy. And schools, and the Fridays. Now, you know what? I'm like, are you freaking kidding me? I was laughing my butt off. I was laughing my butt off when I saw that, and I'm like, are you kidding? Yeah. I'm like, well, you know what? If they would streamline the hiring process and not be a bunch of pain in the ass. Akusta? Akusta and Candy did they? Yeah. Must have won the over something. Yeah. I think, Akusta's so. Yeah. He's gonna be doing some balancing probably. Yeah. And I'm working next Monday for Matt unless you want to. The holiday. No, well, we could be taking a long holiday. If you take a long holiday every day. I'm taking care of it. Take a long holiday this past weekend. Hey, why did Ledoux leave? Well, you should have called in that order. They did call and take your time. They called it in, that's I'll go pick it up. This is our last case with one. Yeah. Oh, good. That won't be a problem. We'll go pick it up in about 15 minutes. Come be in your little trucks. Take the truck. Yeah. Why take the truck? Take your car. What kind of pies did you order? Flavors? Yeah. 4 pepperoni, 2 sausage, 2 meatball, 2 burger, 1 veggie, 3 salads. Ooh. Yeah. Some people do that. Yeah. Oh, no. Yeah, well, I didn't know anything about it. Well, apparently Reagan's closing now.
I mean, their food really wasn't that great anymore.
Red,
Yeah.
it's still, you know what,
It's
the
not
thing about it
acceptable.
was, for us with juries, they were fast and they were good, they were here.
Yeah.
And the orders were right. Because you won't open this thing down in East Carolina unless you go to England.
Where at?
You know where Sherwin-Williams is on the East Trail?
Yeah.
Across from the town center?
Okay.
I think it's in that plaza there.
What is it called?
I think it's called like Black Sheep Barbecue or Black Sheep Bistro.
But that's been there for a while though.
Yeah,
They own that too?
yeah.
Oh, I didn't know that.
And I guess Red is either remodeling and then may reopen or they may not.
But that barbecue place, if that's the one I'm thinking about, across the street from where Rip City used to be at,
Yeah,
that's not that good either.
no?
I didn't think so.
Well, there was one in there before and it went out.
Oh, okay.
It was like, and it was little, that one was expensive.
Yeah,
That
well,
was a couple years back.
okay.
Who did that?
The place was originally, I used to go there, and south, originally he was keeping it the same. That's your shield stuff. So anyway, you gotta have your call, you're gonna need it. Yeah. So anyway, he changed it, and he said it could be better. It wasn't, like, they should keep it the same.
Well, that one solid reasons that truck company was very anemic.
That guy's best.
Well, who goes there?
See, I like the Williams.
You don't like Williams?
I do.
I do too, and there's a salad, there's a specialty salad that we get, and I got, and it was very anemic. There was hardly anything to it. I mean, when I paid for it, I was very disappointed for
Have you tried Marvelous? Do you have anything from them? I love that.
I do like Marvelous. I do like the right up here.
Yeah.
We went Saturday night. We went down our aisle to put out Pelican Bed, and I was disappointed in it. It used to be really good.
I don't know.
The best thing I had was my wedge and lettuce. And I had garlic. I had creamy garlic dressing with great. Yes, look. With my fish, real good.
Wow.
I had vegetables that were fine. They were watery. And my wife, she got the complete shrimp. And there was a lot of shrimp in it, but they put a soy sauce in it, and it was so salty. So salty. Well, it made me happy. Was not happy. It was still.
Not spending that kind of money, you want to be happy for you.
For 2 dinners, and the dinners and tip, $75. Hey, Tom. Yes, sir. Yes, Bob. Bunch of bullshit. No, that's cool.
Don't worry about it. Somebody would have gone, you wouldn't worry about it.
Reason why. You know, there's a reason why you're in the courtroom. Executive position, bro. Yeah. I got you on that side over. So long, Mary. We're going around for 3 years. We need to plug in that. Why wouldn't you go back? Investing, I was telling Lisa, investing your capital is a bunch of money. $5, you know, it's crazy.
From a guy signed a contract 2 days later, sold to Chicago. One day, sold his brakes. They were around $400,000. That was part of the next thing that's happened.
We just built a brand new section of trade. Right across the Walmart and all that. All the way down to the way of 5 times. People down the street. Easy. Yeah, my brother-in-law, he was bring up showcase. He is what he had ready for their house. He built a 6-part garage. So far, and he was on 300. Just really lots of my
And the other things are a lot behind us. Not in the horse street. I mean, put it on the block.
Yeah. How long was your house?
Or sell here.
I want to get out of that. I want to ask. I'm holding that call. I can probably get the answer. And then I It's been 31 years since I was in Indiana.
Here it goes, summer to summer.
Tell you what, I walked there.
Yeah, and you know what, it didn't go cold, super hot, like. I had a couple of decent, maybe 75, but the humidity. Even the morning.
Well, we know around the corner. It's around the corner. Years later, more important than what they're trying to say. You know what? Not because one trying
Well, let me know when you're going on the four-way club, right? Take your drive.
I look at it as we still have, I'll have to look at it. I'll make that, I'll be hungry because tomorrow I gotta take mom.
Paper, that's what all of
I know. Still May.
I feel glum for the private car, stop him. It'd be double points for that. Yeah, I made my monthly stop and.
I was driving a Taurus, I feel
You know, Will used to, for years, and I was so pretty, he was wanting to. So she come up behind me and go on, and I used to. When I think I'm not go right past like the slow car, oh, he used to do something.
Anything I do this is right.
Man, I miss so. There was no better person to have it. But he was a taker, Marco. They didn't want that guy. He was a terrible driver. Everyone told me.
Change like. Here comes the boom. What did you talk over? Yeah, I did. Because you can't be in No. It was, I was offered in the instructions. That's a girl. Oh. We gotta have better.
Steve, you're not good at selling instructors.
We got to run better. You were fighting that one chick from MMA. Not Ronda Rousey, there's another one. She just lost. Holly home to call her? No, she's brunette. Kind of a highlight. She's got a cast on her arm right here. She's lost. She's getting you over there? Yes. That's what we'll say. Your MMA fighting. Don't push that. I got to be with the all right. Brian, don't push back. Yeah, take your time. I gotta beat it. No, rush back because we want food. No. I gotta get this healing done. What's going on? We're already done in about 5 minutes.
About what?
5.
About
she said
25?
Huh?
About 25?
Yeah.
Don?
Because he's gonna have to go over all his notes.
He has to read,
Yeah.
everything he wrote down is gonna read.
Yeah, I don't know what
Sit
you're
down.
thinking about.
Come on, we gotta stipulate that.
That's gonna go.
All right, look, I'll skip like when you read it for my kickoff.
It doesn't matter.
How about if I just beat you to death?
If I fall, break those.
Can I just put a good beat on him?
When's he come back?
He just left.
He
No.
left.
The church.
Oh, I thought you meant Brian. We were talking about Brian.
Oh.
I thought it took a reason to 10:15.
Well,
Yeah, if that doesn't mean
That
nothing.
doesn't mean
The world is not ready for some of this stuff.
I got it. Taking a plane.
Years ago.
Today is Citizen Day.
What is it?
We very did it here last week.
yeah.
So if the judge finds an evaluation or not.
Okay.
Won't be long.
That's rumble. Oh, Judge, ready. Rumble. Call
No.
Jackson already.
He's not ready because Donald gave him more to read.
Yeah. So I think this needs to be continued.
So if you can handle 130, 10 to 130.
I mean, we already got a full document.
I think it should be a given that if you bring in more paperwork,
You gotta come back.
you gotta come back.
Or at least by lunch.
We have 9 cases this afternoon.
Oh, come on.
Yeah. Yes.
Monday?
On Monday.
Better than Friday. I can't do this. I have to make a Travis up. Hey, you got that's a gotta go. This is important stuff, right? I'll be in violation. I mean, you know, crap in Collier County is random. I know.
Well,
Well, enforcement do here. Yeah.
We got 2 pleas and the rest of them are motion. So
yeah.
we should be okay.
Does running a registration check count? I'll give you
Well, if you call up,
I give you my trailer registration, drop your car, and
Oh, yeah, that's good.
Well, it's good to go.
Single 52s have now, which is DAVs, have now become single 75.
Yeah, you gotta get creative out there.
Yeah. Yeah, single 75.
You gotta pull in a parking lot, wait for some old lady to get out of her car, go to the store, she wants you not wanted. And then you run her tag and you call it in. And get your stop. And then you'll get in trouble for that, and they'll change the policy back to stop writing tickets. Or circle, and they don't write.
That's not been mandatory yet. Wait a minute.
Yeah, we record them. You have to stop for it.
Yes. We have to stop.
Yeah.
Damn.
We don't
Stop the first.
Ticket. Are y'all serious?
Yeah.
First, yep. They have stuff out of the car. You have a public tag, man, was suspicious.
So Lisa, do me a favor.
Keep your window rolled up, Lisa.
Let's go out and you commit a traffic violation, I'll stop you, but I promise I won't do you.
Are you crazy? I feel like that's a waste of money.
Yes,
I thought
but you know what? I feel like quota.
I gotta write you a quicker ticket.
You ain't gonna feel it on me.
Yeah, make sure you have your seatbelt on.
Seatbelt, that's the whole story.
Look at her ticket.
I'll sign that.
I'm not writing it. I still don't think that we should have a seatbelt law.
Well, it saves lives, it really does. Oh,
You have a valid point.
Who doesn't know where I'm going in the
You have a valid point. Basically,
They don't even know how to
wearing
see
these
your
seatbelts
count.
is like wearing a mask.
Yeah.
You think it should have saved your life. No, they're all good statistics. Seatbelt does save lives.
He didn't even know there was.
Well, there's good statistics we save our lives.
I don't know about that.
Yeah.
That's fake news, brother.
It's still out there.
That's fake news.
Hey, guy, they say you drove a tractor to school.
Guy wouldn't
I
get
did.
a wagon and a horse, he didn't even know it.
What do you mean?
He hits like a
We didn't even have tractors. We still have horse and buggies around.
Yeah. You remember those little black hats, the little round hats?
It's not like Amish world.
Yeah.
Oh, my
Seatbelt,
God.
we don't put that on horses.
Or motorcycles. But there is a guy that invented a vest for motorcyclists. It's like you put it on like a jacket, and it like is a bag, it wraps around you. It inflates like your front and your back.
So it's an airbag for a motorcycle ride.
I don't know if it's on the market yet, but I see some prototypes for it. I mean, I wouldn't wear one, but
You know,
That ain't gonna do much good.
everybody thinks my real name is Guy and they call me Pete. Yeah, my real name is
it's
Greg.
supposed to cover your whole, it does cover your head now. Yeah, it covers like a whole lot. Yeah, it's crazy. What'd you say, Pete?
I said, everybody thinks my first name is Guy and they call me Pete, but it's really Graver.
I call you Geek.
There's a lot of names.
I was the drummer in the Electric Amish.
I call you Snapperhead.
How they call Lot.
These attorneys have important things to do today. They can't just be sitting around there.
I don't know. There's a lot of things to be weighed. A lot of thought. You know what? We can blame Donald on this.
This one you probably can.
This one we can blame Donald on.
I hear a comment.
We hear a comment.
That could be- I-
You're like a cat.
You hear that, Lisa?
Yep. I don't hear it on purpose.
See, I told you.
All rise, Carter County Circuit Court is back in session.
Welcome back. Sorry for the delay. I did a lot of thinking on this.
I told you.
We'll wait for Mr. Avig to return. 20 CF 1202. Did Mr. Day keep you entertained, Madam Clerk, with stories about the state of Maine?
He did, and about that.
Okay.
And some good stories about Guy.
Me and Mr. Day go back a long time. 31 years.
All right, Mr. Avig is now present. Welcome back. Let me go through the analysis here. Mr. Avig is before the court, having been placed on supervision for the underlying offense of burglary of an unoccupied structure of conveyance. It was actually a conveyance initially. There were 4 violations alleged: possession of controlled substance, using intoxicants to excess or possessing drugs or narcotics unless prescribed, leaving county of residence without consent of probation, and failing to make a truthful report on the form provided regarding not having had contact with law enforcement. The violation report submitted by probation indicates that Mr. Avig has previously done a weekend work or lockdown 10 days on this case, that there was no treatment ordered, that these violations, if found, Department of Corrections or Probation is recommending revoke and resentence to 6 months jail followed by 1 year probation to include substance abuse evaluation. Looking at the order of probation, Mr. Avig pled no contest to the underlying charge. Adjudication was withheld. There was a 1 year probation term, 10 days county jail, weekend work. There are standard conditions of note. Number 3, you will not change residence or employment or leave the county of residence without first procuring consent of your officer. Number 5, you will live without violating any law. A conviction in court is not necessary for the violation to constitute a violation of probation. Number 7, you will not use intoxicants to excess or possess drugs or narcotics unless prescribed. Number 9, you will promptly and truthfully answer all inquiries directed to you by the court or the officer. It doesn't appear that there's any other specific or standard conditions that would affect the analysis here. The underlying probable cause affidavit indicated that this was where Mr. Avig was observed by people in the neighborhood inside a vehicle. When asked what he was doing, he replied he was in his vehicle and then continued to rummage in the vehicle and nothing was taken or damaged. The only other thing I would note, well, I'll get into the evidence at the hearing. With regard to the hearing evidence, Officer Belinda Mata, the probation officer, testified there was no dispute that Mr. Avig has explained the terms of supervision. The probation officer was rather firm in her insistence that there was no permission for Mr. Avig to be out of the county on January 22nd of 2021, and that he must inform on the form of all law enforcement contacts. On cross-examination, the probation officer admitted that that Mr. Avig had made her aware that he works in both Collier and Lee counties. Officer Matthew Kale from Lee County Sheriff's Office described how on January 22nd, 2021, while on another call at a parking lot in a commercial establishment, his attention was drawn to Mr. Avig and resulted in investigation for narcotics. He was assisted by Deputy Luna. Officer Kale said that consent was obtained for Mr. Avig to search the vehicles. Narcotics were found. This all happened in Lee County. Officer Kale also described that Mr. Avig had what he called erratic behavior. Officer Luna testified also at Lee County Sheriff, claims that Mr. Avig consented to the search and that in the vehicle, in a cigarette box on the passenger seat, were found pills. They were photographed. They were introduced into evidence as state exhibits 1 through 3. These pills had inscriptions on them. Officer Luna says that these markings led him to look on the internet to a website, and that it indicated that this was a Schedule II prescription drug. He said that he asked Mr. Avig about this, and Mr. Avig's response was that he had no idea whose pills they were or what they were, and that he only takes ibuprofen. He did say that the cigarette box was his. He also stated that Mr. Avig was acting erratically, as in distress or abnormal. Mr. Avig testified at the hearing. He resides in Naples. While on probation, he was also working in Lee County and said he sought permission to be in Lee County for work purposes. He said he opposed the search that was done, that he did admit to subsequent discussion with the officers. He mentioned that marijuana was found, but he has a marijuana card, and that he has tools that could be mistaken for use in the trade. He mentioned specifically razor blades. He said the pills were not his, and that's what he told the officers. So, the arguments that were made with regard to the possession of controlled substance, the defense argues that the only evidence was hearsay from the website as to whether it is a controlled substance, and that while hearsay is admissible, it cannot be the sole evidence of violation. In rebuttal, the state argued that the photos of the pills show markings and that the defendant had admitted he did not have any prescriptions. As to condition 7, closely related, which is the either ingesting or taking intoxicants to excess or having possession. I'll refer to the condition again. It's not using intoxicants to excess or possessing drugs or narcotics unless prescribed. Again, the defense argument was there was no direct evidence of any ingestion of any intoxicating substance. The state again emphasized that it's either use or possession, and there was no prescription. On this, I believe the state has not proven this violation. I agree with the defense on both of these. There's insufficient evidence. The only evidence was hearsay that the officer supposedly consulted a website. There is no field test. There's no other laboratory confirmation. There's no testimony from someone with knowledge directly as to what that means, as opposed to a reference to some website. I find that is insufficient. The only evidence is hearsay, and that is not corroborated. So the court finds no violations of condition 5 or 7. With regard to the condition of leaving the county without informing probation or getting permission, this is in dispute. Mr. Day correctly stated this is a credibility issue. In looking at this, I have considered how the witnesses testified as well as what they said, how it relates to the entirety of the evidence presented. I also take into account that Mr. Avig is a convicted felon. He does have a greater interest in the outcome. On this, I believe the probation officer was quite clear that specific permission was not sought. That evidence is credible and outweighs the testimony given by the defendant. The court will find a violation on that ground. And then we get to the most interesting one, which we were talking about also this morning, which is this condition that says in condition 9, you will promptly and truthfully answer all inquiries directed to you by the officer. There is no standard or special condition for Mr. Avig, or in general, I guess, that says that you have to report law enforcement contacts. There is, I'm told, a form. It appears undisputed based on the arguments of counsel and the evidence that there is a form that is required in all cases by probation, requiring all probationers to inform if they have had contact with law enforcement. Mr. Day's argument on this is that unless the conditions, special or standard, reference the law enforcement contact, if this is purely a creation of probation and should not be the basis for a violation just because it appears on a form. He argues that it could lead to absurd interpretations because probation on that basis could ask questions about things that are far afield of anything related to probation and still find a violation if the individual did not report it. The state's position on this is that it relates to other standard conditions of probation, and that in Mr. Avig's case in particular, there really should be no doubt because it was a substantial interaction about a criminal investigation where he was cuffed and detained, not something that would be overlooked and that does relate to his conduct while on supervision. This morning, Mr. Day, he alluded to case law before he introduced it to the court, 22-7-3-708, the Jennings case, a 2009 decision from the 2nd District Court of Appeals. There were 2 violations at issue there. One was a officer had issued citations for 2 driving related violations. The reversal in Jennings resulted because the state had not introduced sufficient evidence of a willful violation. I think it's because they didn't introduce evidence that that defendant should have known that his license was suspended. But that's really not the crux of the case for our purposes. The crux of the case for our purposes is the other condition about not reporting law enforcement contact. And it specifically references the form we're talking about in the opinion. Interestingly, it says something that parallels a little bit of our situation. In the footnote, it says, we express some concern that the form is not included in the appellate record. Our efforts to obtain supplementation of the record to include a copy of the form were unsuccessful. However, the transcript of the revocation hearing indicates that the form was introduced in evidence at the hearing. Well, none of that happened here. However, I also think that the record is undisputed here that this provision exists in the form. So overlooking that procedural issue, we look further to the language in Jennings. In Jennings, the court goes on to explain that the probation officer testified that Mr. Jennings answered no to the question about contact with law enforcement. We can understand how in preparing the monthly report, a person on probation for 2 serious felonies might overlook a traffic stop. However, Mr. Jennings' explanation for omitting to mention the traffic stop was unconvincing. The violation was supported for failing to make a full and truthful report was supported by competent substantial evidence. In review of a probation revocation order, the applicable standards of use of discretion, whether Mr. Jennings committed a willful and substantial violation by falsely reporting no contact with law enforcement may be arguable. However, we are unable to conclude that the trial court abused its discretion in so finding. So Jennings is not exactly on point, but it does have language which I think does help to put matters into context. It appears to be a matter that is specifically on point, not resolved, and could be a matter of first impression. In this case, looking at the language I've cited from Jennings, I will find the violation for failing to truthfully report. The reason for that is, even though the contact with law enforcement is not in the special or standard conditions, it is in the form. This question is not unreasonable. It does relate to other standard or special conditions. And in Mr. Avig's case, it's not being unfairly applied, because this is not a matter of Mr. Avig being approached by an officer and asked, you can't walk here, it's jaywalking, you need to walk up at the intersection. This is a substantial interaction, part of a criminal investigation. Mr. Avig was detained. It related to his other conditions about whether he was out of the county and was stopped by authorities in another county. So at this point, I think the Court of Appeals will have to resolve the broader issue. But for now, I find that question on the form is a reasonable condition related to standard or special conditions, and that as applied in Mr. Avig's case, it is not unfairly applied because it did involve substantial contact. So that violation is found. Mr. Ashby, what was the state's position? I have found 2 allegations not proven. I have found 2 allegations proven. What is the state's position on this, as far as disposition of the violation?
Your Honor, as far as disposition of the violation, I think one that the court found is that the defendant back here. The court found that it's a willful and substantial violation.
Yes. On the not reporting the law enforcement contact and on being out of the county without probation approval.
Then, Your Honor, I think at this point we are pushing the defendant.
Right.
So the state would, if one more, Your Honor, I think it's support you for one thing. Is that on there or not? Your Honor, the state would be requesting that the court revoke or resentence the defendant to non-Collier County Jail, credit for all time served, term to remain outstanding, convert any monetary obligations that are outstanding to or send them to collection, and issue a new $100 cost of prosecution, any applicable cost and any
Mr. Ashby, that seems to differ from the probation recommendation in this case, which was, I believe, 6 months county jail with substance abuse evaluation, follow recommendations, and an additional year of supervision.
Yes, Your Honor. State's position is that understanding that is the probation's recommendation. State position is that the defendant, at 2 points, was out of county, he was untruthful to the probation officer, as the court has found in the allegation, as the court has found. That does not make the state position defendant not amenable to any further supervision. We would be best to have him at this point terminate, have his probation not continue. The probation's recommendation would be essentially to, after he serves jail time, be put back on probation for a period of time. I believe that state position is that he is very likely to be back here in the same situation.
What about in the underlying case? It was a withhold of adjudication, I believe, based on no prior criminal history. What would the state be requesting there?
They would be requesting that the defendant be adjudicated guilty at this time.
Anything else?
Nothing else, Your Honor.
Mr. Day?
Your Honor, the defendant has no prior criminal history. This was the first violation of the law. We would ask the court for a modification. The violations for which the court has found that he committed are de minimis violations. They didn't exist, but they're not significant violations. No new criminal law, offense, crime of violence, or anything else out there. And lack of the defendant's prior criminal history, there's nothing to indicate. Frankly, I don't understand why this recommendation of incarceration on this first violation coming from either the state or the department. It seems to be out of the ordinary of what typically would happen in a de minimis violation. However, as people can suggest what they want, but I would suggest to the court that in light of his clean record, his work history, he's been in custody since March. He has lost pretty much all of his employment at this point, which puts him in a significant bad position when he gets out. He's going to have to do with as best he can. But in his lack of record of the de minimis basis of this violation, I would suggest to the court that a modification line to keep his withhold and allow him to complete the terms and conditions would be appropriate. In whatever terms the court may deem additional conditions that the court may feel necessary, that he be allowed to be able to get out, and get back to work. There is an incarcerated point of this, even if the court goes along with the defense recommendation in custody March 17th.
March 17th.
Yes.
Now, two questions, Mr. Day. What's that?
Sure? Hold on a second, let me double check here. That doesn't necessarily mean the day you serve his violation of probation. I think he was arrested on the 3rd. I could be wrong, so it's either got the 3rd or the 17th, but the point is he finished the 3rd one.
Mr. Day, what would be the effect on Mr. Avig's livelihood of the underlying charge becoming an adjudication?
Your Honor, he is an overland trucker, and the problem for that is he hauls loads, as all overland truckers do. Sometimes require that the criminal background checks be conducted depending on the load they're hauling, traveling from state to state, driving a commercial license, all of those affected becoming a big felon. For instance, all of the companies now that are up to speed with the modern trends in the world, like Amazon and places like that, require a background check. You can't have prior criminal history to drive product for Amazon or any of those other Walmarts. So it has a significant impact.
The other thing is you argued that this was a de minimis violation, but the court considers that the supervision system relies on probationers being honest and upfront with probation officers in order to effectively administer the probation system. That seems to be more than a de minimis concern.
Two of the reasons I say de minimis in this case, first of all, he's allowed to be frequent back to firearms. And the fact that he's going back and forth and he forgot to email her, didn't really come out of evidence why, but I don't think that's a violation. In light of his traveling every day for provision. Secondary issue is contacting and letting them know. You know, this issue comes up all the time, and are these offenders really clear that every time they talk to police officers that they are to put that in their report? Or
well, I understand that part of it.
I mean, and that's what I mean by de minimis. I understand exactly what you're saying, but he wasn't arrested. So, you know,
I was looking more toward the violation that was found about the, well, that's fine.
Yeah, so, I mean, I guess the point, I don't mean to minimize it, I'm not suggesting that. I'm just saying that it's not as egregious as someone who's been on probation, living in Collier County, and they're found in Orlando for the very first time.
Does the defense have any objection to the substance abuse evaluation follow recommendation?
No, Judge, and that's why I suggested that the court keeps that appropriate as an additional condition. There's still probation time left, So there's still conditions the court can impose to make sure. he's
How far into the supervision was Mr. Avig at the time of this violation?
Let's see, the judgment says reflects that we did this on November 10th of 2020. Is when the original sentence was imposed.
Anything else, Mr. Day?
No, sir.
Mr. Ashby, any rebuttal?
Or, please note that, again, the violations for which have been found, the defendant was untruthful, and he was untruthful, and was a place where he wasn't supposed to be, at a time he wasn't supposed to be. If the court is inclined to put the defendant back on probation, they point out would know that he pled on November 10th, 2020. That would put us, the court's jurisdiction would run on, I believe, November 9th of 2025.
All right. So the court has found 2 of the 4 violations. Probation seems to believe that Mr. Avig is still amenable to supervision. He was granted a withhold adjudication. He had no prior criminal history. Probation has recommended 6 months county jail with an additional year of supervision. I don't think that based on all of the circumstances, that amount of incarceration is needed. The court will, and I'm not sure, Mr. Day, if this would be better phrased as revoke and resentence or as a modification, and you can address that if you wish, but the net result that I'm looking for is that I would be inclined to order, and it's primarily not so much because of the being out of county, because I understand that Mr. Avig had communication with his probation officer. They need to get that straightened out, and Mr. Avig needs to make sure what those requirements are. The bigger concern was the not truthfully reporting a substantial law enforcement contact. I believe that in this circumstance, with everything that's been described, the probation the state is asking for a total revocation with an underlying adjudication. Probation was asking for 6 months with additional supervision. The court believes, based on everything I've mentioned, that 90 days with credit all time served on this violation is sufficient, adding 6 months to the supervision and requiring a substance abuse evaluation and follow recommendations. Mr. Avig doesn't have any prior criminal history. I have not found the drug-related violations, but the behaviors were such that I think it does warrant checking if there's an issue or not. Mr. Day, any comments? I will maintain the underlying withhold.
It would be, it would need to be a modification of probation, adding the terms and conditions, he sentenced 90 days prior to county jail, corrective time served. He received a substance abuse evaluation, follow recommendation, and probation be extended for 6 months.
Mr. Ashby, any clarifications?
Mayor, I would have to be, state would agree that the court sentence that maintained the withhold would have to be a modification.
Right. Yeah, and that is what this will accomplish. This being a first violation with no prior criminal history, this will better enable Mr. Avig to be gainfully employed with that withhold remaining, so long as there are no further violations.
And yeah, I was prepared with the modification order. Okay. Are you extending it 6 months from the November 9th?
Correct.
Yeah.
And carrying forward all original.
Yeah, so the year is 6 months, basically.
Sure.
Any other clarifications needed, counsel? So ordered. That concludes this case.
90 days, credit time served, substance abuse, random testing, and probation extended
6 months.
6 months.
Yeah, and all carrying forward all original conditions. Prosecution costs 100. Any investigative costs, Mr. Nashby?
Not aware.
And there are no court costs. And you're preparing an order, Mr. Ashby? Thank you. And let's clarify, Mr. Day, because of the time served issue,
So all you have to say is time served, when I'm explaining to him,
I'm going to put in credit all time served.
Yes.
So as long as that's verified that he came in on the 3rd on this case, then he would get that credit.
but the way it works, Mr. Adams, if I'm on probation and I commit a new crime of stealing a candy bar and I go to jail for the candy bar, it may take a week to 2 weeks for them to know I got a new arrest and serve me the warrant for violation of probation. The day they serve me the warrant is the day I start serving my sentence on violation of probation. So I could be in jail for 5 days on the candy bar charge where they serve me the warrant on the violation of probation. All the judge is telling you and I'm telling you is you're going to get credit the second they serve you that warrant. None of us know exactly the day that was done. Does that make sense? And I'm going to double check all that right now as soon as we walk out. So I think all you have to say, Judge, is credit for service to the warrant of violation.
So, and Mr. Ashby will reflect that.
Yes, sir.
Do you see it, Brian?
I do have, perfect what I have.
That'll answer.
Well, let me ask you this, Mr. Day, in fairness to Mr. Avick, do you expect there could be, from what he was describing, from March 3rd to like March 17, that gap, which is substantial.
Yeah, here.
Does the state oppose him getting credit if that's verified?
I have that he got credit. I got him the warrant to serve on March 13th. That's the only thing that I have. I don't know when he was arrested.
Right.
So he was arrested on the 3rd.
Was he arrested for other charges or
His
just,
possession charge?
so he was charged with possession in Lee County?
Yes.
All right, so it's gonna have to be from service of the warrant, because that was what relates to this. So it would begin on the 13th?
Yes.
Any debate with that, Mr. Day?
No, so.
Is there any argument why he should get credit?
He had a hold on him the day of his arrest March 3rd, but a hold is not a service of the warrant. But would the court consider this, 80 days jail instead of 90?
Well, did he bond? Was he able
Yes.
to bond on the other one?
Yes, but then because of COVID, he sat, I think, for about a week and a half before they could get him service of the warrant and then get him down.
Well, I think under the circumstance, I'm willing to give credit back to his initial incarceration date in Lee County, which was March 3rd, I'm told, as long as that can be confirmed.
If that's the date of the arrest, I do have, let me just double check.
And he was taken into custody then?
I just want to be sure about it, so I want to say something. Okay. I guess go to the sheet. Are you sure? I think we received the PC affidavit from the county SO.
I'm showing.
So credit from March 12th?
He
It
said
could
he
be,
arrested March 3rd.
right.
I have paperwork in myself.